Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.
Welcome to our Savant Live webinar. We're so thankful that y'all could join us today. My name is Alaina Davalos, and I'm a wealth transfer advisor at our Atlanta offices. Today, we will be discussing Estate Planning 101. So if you are new to that area or you're beginning to work on your estate planning journey, this is the right webinar for you. And joining me today, I have Dominic Parillo. Welcome, Dom.
Glad to be here. As Alaina mentioned, I'm Dom Parillo, and I'm joining you live from our Manassas, Virginia office. And when Alaina and I were creating the content for today's presentation, we really, like Alaina said, wanted to keep in mind people that are just trying to get started when it comes to addressing their estate plan. So we wanted to design this to be like a 101 type class, hence the title slide, Estate Planning 101. We're going to cover a lot of basic terminology, some foundational concepts. And I wanted to start today with a sort of a fun trivia question, and you may know the answer to this, but what did Abraham Lincoln and Jimi Hendrix have in common? Alaina, I think you might know this.
I think I might, but I don't want to ruin your surprise, Dom.
Okay. They both died without an estate plan. Kind of interesting. It just goes to show you, not good. And it doesn't matter, how famous or prominent you are. A lot of people put off estate planning because it's not always approachable and it can be a little bit intimidating. So today, we really just want to help you understand, what is estate planning? Why is it important? What are the key documents that I'm going to put in place with my attorney? How does my property pass, right? The things that I own, my assets, how are they accorded with my estate plan? What are some tips and tricks for communicating my plan with my loved ones? This probate process, what is that? What type of work are my family members going to be expected to do after I'm gone? And then we'll round out with a brief overview of the federal estate tax system. So next slide, Alaina. What is estate planning? Well, it's really the process of designating who's going to receive your assets, the things you own at your death, and handle important decision-making responsibilities if you become incapacitated and you're unable to make decisions for yourself. And then who's going to be responsible for administering your estate and distributing your financial assets to your loved ones in accordance with your estate plan. And I think it's important to keep in mind that even if you don't have a formal estate plan right now, legal documents, you actually have a default plan, and it might not be the plan that you envisioned. Because believe it or not, everyone that doesn't have an estate plan, if you pass away without a will, your assets will be subject to state intestacy statutes. And the state you live in has pre-designed who will receive your estate at your death. And it might not be the people that you were thinking. And if you're charitably inclined, charitable organizations that might be important to you are not going to be any of those state designated beneficiaries or recipients. And a common goal with estate planning is to make sure all of your assets are distributed in accordance with your wishes and really make things easy. We want to, have a smooth transition to your loved ones and heirs, and minimize taxes, legal expenses, and maybe even provide some important asset protection features if that's appropriate as well. We got a famous quote from Ben Franklin: "Failing to prepare, you are preparing to fail." And like we said earlier, everybody should have an estate plan. It can be basic or it can be more complicated, depends on your needs. How often should you review your estate plan? Our slide says annually. I think it's important to review your balance sheet, your net worth statement, take an inventory of what you own, right? What your debts are, probably annually, because that's important, especially from a titling standpoint. And Alaina is going to get into a little bit more detail later. But really, when it comes to reviewing your estate planning, your estate plan documents themselves, whenever there's a significant change in your life, increase in net worth, change in your family situation, someone gets married, divorced, birth of a child, grandchild, that sort of thing. or if there's a significant change in estate tax law. Those are typically reasons that prompt it. But I would say, probably every 3 to 5 years with the documents themselves. But be thinking about it, be taking inventory of your assets at least annually. All right. So what are the key legal documents that comprise an estate plan and what you would ultimately want to work towards with your attorney? And we're going to kind of cover these in order of when they would become effective for most people. So when you think about the basic building blocks of an estate plan, you have power of attorney forms for both property and healthcare. And we're going to define what each of these documents are and what they do in a little bit more detail in the next few slides. It's important to have a living will or advance directive to supplement your healthcare power of attorney. And then, of course, the quintessential foundational document, a last will and testament. And then most people, I think, can benefit from the use of revocable living trusts as well. So let's start with planning for your incapacitation with powers of attorney documents, power of attorney documents. Why is this important? Well, if you don't have a power of attorney document in place that designates an agent to make these important decisions for you, if you are illegally incapacitated, a court would actually appoint either a guardian or a conservator to take control of your financial estate and also make healthcare and medical decisions for you. And generally, people want to avoid this. This is not typically a good situation. It's very time-consuming, burdensome. It can be expensive, right? Depending on the rules in the state that you live in, your conservator or guardian might have to get approval from a court before they can start paying bills on your behalf or covering other expenses. It's a really supervised process, and generally want to avoid it. So how do you avoid that? Well, you would create legal documents called powers of attorney. And there's two different types. You have a power of attorney for property, which allows you, the principal, the person creating the document, to nominate an agent under the document. And your agent, the person you name, can act as if they were you for making financial decisions and transactions. The important thing to keep in mind is that I think all states allow for durable powers of attorney, which means that if you do become incapacitated, your agent can continue acting on your behalf until the end of your life. And it's important to keep in mind that these power of attorney documents only are effective while you're living. When you pass away, as Alaina will explain in the next few slides, your estate is administered by either your executor or your trustee under your revocable living trust document. Again, that financial power of attorney would be handling financial matters, right? The other document that is important and you should also have is a power of attorney for healthcare. And like the name suggests, your agent would be making healthcare decisions on your behalf as if they were you. And then to supplement your healthcare power of attorney, we often advise clients to consider implementing living wills or advance directives. The terminology is a little bit different depending on the state that you live in. But basically, your power of attorney for healthcare document authorizes your agent to make those decisions when it comes to medical and end of life decisions, right? Giving them access to your healthcare records so they can be informed and make the right decisions. But oftentimes the default power of attorney for healthcare document doesn't specify your end of life wishes, right? Whether or not you want artificial nutrition or hydration withdrawn or administered. So a living will declaration can actually allow you to specify how you want these very sensitive and delicate end of life decisions to be handled, so you can remove the decision-making burden from the shoulders of your family members or loved ones, whomever is going to be serving as that agent. So hopefully this makes sense, right? These are documents in place that deal with your incapacitation generally, and they're effective during your lifetime. And I think another important note is, these documents would be effective for assets that are in your name individually, right? It's a little bit different with a trust, and Alaina is going to talk about that. So on the next slide, we have a couple of planning pointers as you think about how you might design these different documents. So the power of attorney for property, we get the first bullet point, statutory forms. Most states, not every state, but most states actually have prescribed language that your attorney would use in the document itself, embedded or created and included in the actual statute, the state law that allows for the creation of the power of attorney for property document. And as a practice point, most attorneys, and we agree, tend to favor those statutory forms for a lot of reasons. Number one, the local financial institution that you work with, the bank, and even healthcare power attorneys can be statutory as well. That hospital, they might be more familiar with that state form, and oftentimes the state forms provide a little bit more comfortability for those persons that your agents are going to deal with, because they might be protected, right, in reliance on taking instruction from the agent from a legal standpoint. So certainly we would encourage you to use statutory forms.
So Dom,
go ahead, Alaina. Yeah.
if someone were to move to a new state, is this a document you would recommend getting updated?
I generally think it's a good idea. I mean, one of the reasons, I didn't mention it on our first slide, when should you review or make updates to your estate plan? Whenever you have a change in domicile, I think it's good, Alaina, to update your documents, or at least have them reviewed by an attorney licensed in the state that you move to refresh things. And that way, your new team of professionals or healthcare providers in your new state will then be familiar with that new state's documents. Is it mandatory? No. A lot of states recognize, for the most part, powers of attorney document and other estate planning documents, for that matter, that are executed in other states, but it tends to be more optimal, right, if you're using your actual state's domicile. And sometimes you might split domicile. Right, we have a lot of clients who have vacation homes in Florida or other parts of the country, and some attorneys actually create two sets of documents. One for their home state and one in the state that they vacation at as well, so they can provide the forms to the local service providers there. So good question, Alaina. And then when you think about how these documents can become effective, right, when your agent can act, there's really two approaches. You can have a springing document, which says my agent can only act when a physician, for example, who's personally examined me, certifies in writing that I'm incapacitated and I'm unable to make decisions for myself. That's called a springing power of attorney. So your agent would take the power of attorney form, and then you have to get this opinion from your medical doctor or practitioner, and then they would take that written form from the doctor along with the power of attorney and present it to the bank, right, or your financial institution, before you could actually act and pay bills on behalf of your loved one. The other way to do it, and this is what we generally prefer, and I think a lot of attorney practitioners would agree as well, is making the document effective immediately. So you just give your agent the automatic and instantaneous authority to start acting for you. I think that makes sense in a lot of cases. There's a lot of different opinions on it, but one thing that I always emphasize when we're engaging with our clients is, hey, if you're choosing an agent, you should choose someone that you trust, right? And if you get the right people in the right seats, then it shouldn't be really that big of a concern that they have this immediate authority to start helping if they need to, right? If you don't trust someone to make the right decisions while you still have capacity and are able to intervene, why would you name that person to make decisions for you when you are actually incapacitated, right? And again, facts and circumstances and mileage will vary there, but that's just our general philosophy. And then I think this is true for both the power of attorney for property and healthcare document. It's good to name multiple successor agents, right? Have a deep bench of people in your document. It creates a little bit more longevity. The document's going to last longer, but just because you're named as an agent under a power of attorney document doesn't mean that you're always going to be available to act, right? It doesn't mean that you have to act. You can always resign And so again, you want to avoid that court-appointed guardianship or conservatorship scenario. So having a list of several people, I think, makes sense. A couple other points here. We are often seeing that digital asset planning is becoming part of contemporary estate planning because everybody has a digital presence, right? And we're not talking about online banking here. It's more of your email, Amazon accounts, social media, right? So I think it's important when you're working with your attorney to include express digital asset authority in the documents to give your agent the power then to access those online accounts. A tip on power of attorney for healthcare and advanced directive. We like to suggest that in the documents themselves, or maybe a separate addendum, that you include the contact information for the people you name, like cell phone numbers and addresses. That way, when you provide the document, and again, this is the power of attorney for healthcare, to your physician, they can make it part of your electronic medical record. And if there's an accident or illness or injury, they'll have the contact information for your loved ones that are named as agents, so they can reach out to them if needed. So hopefully that gives you a good overview of what these power of attorney documents are, what they do. Start thinking about who you might name as your agent is the big one, and your attorney can help design the document from there. So Alaina is going to speak to wills and trusts next. And again, this is with regards to post-death administration. So Alaina, I'll pass the torch to you.
Yeah, thanks, Dom, for that information. So the other really big part of any estate plan is going to be the last will and testament. And many people are pretty familiar with that term. The will is usually the core part of your estate plan because it details what happens to your assets at your death. So what exactly is a will? It's a legal document that expresses a person's wishes as to how their property should be distributed after their death and names a person to manage the property until those final distributions are made. A person who creates a will is called a testator. You may also sometimes hear the feminine version of that, which is the testatrix. And unlike your powers of attorney that can come into effect while you're still living, your will only comes into effect once you've passed away. So let me reiterate that. Your will only come into effect once you've passed away. And what this means is that your will can be changed up until your death, as long as you have your testamentary capacity. Testamentary capacity means your mental and legal ability to create that valid will. If you do not have testamentary capacity, you cannot change or create a will. This definition becomes very important when someone starts dealing with physical and mental health issues that affect their ability to understand, such as Alzheimer's or dementia. So, how exactly do you create a will? Well, state laws control what makes a will valid. So the requirements to make a will in Georgia may be different than the requirements to make a will in Illinois. There may be certain requirements as to how many witnesses you need, whether you need a notary, whether it can be digitally signed, and that's a new thing that we're seeing. Some states allow a handwritten will, which is called a holographic will, to be valid without witnesses, while other states do not recognize holographic wills. It's very important to understand what makes a valid will in your state, which is why it's usually best to consult with a local attorney to see what your options are. So, what assets generally pass under a will? And this is a big planning point in terms of your estate plan, because please note that your will only controls certain assets. Those are going to be assets that are in your name at the time of your death that you do not own with a joint tenant with rights of survivorship and that do not have a beneficiary designation or POD, TOD, which stands for payable or transfer on death designation. Usually your bank accounts and your brokerage accounts in your name alone, yes, those will pass under your will if there's no joint owner. A 401k or an IRA that has your spouse listed as a beneficiary, no, that will not pass to your spouse via your will. It will pass via that beneficiary designation. Another example, a piece of real estate that you own with your siblings as joint tenants with rights of survivorship. No, that real estate will pass to your siblings automatically, not under your will. I'm going to show you a graph in a minute that goes into more details about how those assets pass. You know, the down. Hmm?
Hey, Alaina, I was going to ask you,
Yeah.
how does a will impact the planning for people that have minor children living at home with them? Could you speak to that?
Yeah, of course. So one of the things that a will can do is two things for minor children. The first is to name a guardian of those minor children. So, where would your children go? Who is going to be legally responsible for them? You know, you can have that say over those minor children or an incapacitated adult child that you have legal guardianship of. The second thing that your will can do for your minor children is instead of having them receive assets outright, which if they are minors in most states you cannot have, you can create trusts for their benefit and you can name a trustee. So someone who can manage the funds for your children until they reach a certain age. If you leave assets to minor children outright and they're underage, usually there'll have to be a conservatorship and a guardianship for them. And that's instituted and overseen by the court. The downside of that, anytime there's court involvement, it gets very expensive. Who you would want to have as the conservator managing the money may not be the person that you actually wanted. And so it's a lot better for if you have minor children to have these terms in your will if you're going to be passing assets to them. So, generally, though, another issue that you run into with passing assets under a will is that the will has to go through the probate process. Probate is the act of proving a will, and I'm going to give you a little bit more details about that again in a minute. The good thing about a will, though, is that you can choose who your beneficiaries are. You know, generally, you can benefit anyone you like under your will. In some states, it can be harder to disinherit a spouse or minor children. So, again, make sure you talk to your legal counsel if you're planning on doing that. But for most people, you know, your will, you can leave your assets to anyone you like. Many wills will separate distributions of personal property, which is your stuff, you know, things like your jewelry, your cars, silverware, versus the bulk of your estate, which is called the residue. So everything else that your will controls. When I was in private practice, I had a lot of clients that struggled with what to do with their stuff because nowadays a lot of people don't want their parents' fine china or big furniture. You know, those adult children, they're already set and established in life with their own stuff. And that was a really big struggle for a lot of clients to figure out. A lot of states also, they do allow for your personal property to be distributed via a separate memorandum. So your will says, okay, I leave everything to my spouse, but I may make a few specific bequests in a written memorandum outside of the will. And so if you do want your china to go to your sister who might actually like it, or some jewelry to your grandkids, you know, it's a lot easier to have that separate memorandum than to have to go back and amend your will every time you want to make a change like that. But for the residue, generally, and especially if you want to make any large gifts, you know, you would write that down in the will itself. And you can make specific gifts, percentage gifts, or formula gifts. You know, you could say, for example, I leave 10% of my estate to my church and the balance to my kids. You could also say another example, I leave $50,000, a sum, to each of my nieces and nephews and the balance to my siblings. Or you could do any combination of the two. Really, the world, or the will in this case, is your oyster when it comes to deciding who receives your assets. And you can also, this adds another level of complexity, you know, you can also decide to leave assets outright to those beneficiaries or in trust. As I mentioned, you know, for Dom's question earlier about minor children, you usually want to leave those assets in trust as opposed to outright. I certainly don't know any 18-year-old that should receive a substantial inheritance. Making sure those assets stay in trust until they're a little bit older, a little bit more financially mature, can be a good decision for you and your family. More complicated wills will create irrevocable trusts for spouses or other descendants. These trusts can provide substantial asset protection and or tax planning opportunities for those beneficiaries. I think that generally trusts have gotten a pretty bad reputation over the years. A lot of people see them as the testator trying to control from the grave. However, recent changes to many states' trust laws have made trusts much more flexible, which makes them a lot more attractive. It makes it a lot easier for the trustee to manage trust funds, to make distributions, to make changes to the trust. Um, and these trusts, if you do decide to put them under your will, these are called testamentary trusts, and they're only created at your death. On the other side of that, we have something called a revocable living trust, which is actually a trust you create during your lifetime. And it is another estate planning tool that parallels your will. So, the revocable living trust, or RLT for short, is a trust that can be changed by the grantor, which is the person that creates the trust during their lifetime. One very common misconception I see a lot is people confusing a living trust with a living will. A living will, as Dom explained earlier, is a healthcare document that states how a person wants to be treated medically if they're in any sort of health emergency. The living trust, which I'm talking about here, is a tool used to avoid probate and to plan for incapacity. They're very different. So keep those definitions in mind. With an RLT, the grantor names an initial trustee and beneficiary who are usually the grantor themselves. Sometimes a spouse is included as a co-trustee or as a permissible beneficiary. And that RLT, it's usually going to cover 3 scenarios. The first is while the grantor is still alive. How is the trust used for the grantor? The second is when the grantor passes away, but is survived by a spouse. And then that third scenario is at the surviving spouse's death, or if the spouse did not survive the grantor, when it comes time for their kids to inherit. So those second and third scenarios where the spouse or the descendants inherit from the grantor can be the exact same provisions as you would have under a will. An RLT is most commonly used as a will substitute in order to avoid probate. Because, unlike a human, a trust doesn't die. So the assets that it holds do not need to go through probate. And you can have the same asset protection, create the same testamentary trust, do anything that you could do with a will. You could do it with an RLT, but have it be a lot easier process for your beneficiaries. So why doesn't everyone have an RLT? I was working on this script and I just threw it out there into the office earlier. And the advisor walking by, he said right away, because it's expensive. And I said, yes, because setting up that RLT, having a revocable trust-based plan can be more expensive to establish than having a will-based plan. A revocable trust is usually a longer document and it needs to have a pour-over will with it as well. Why? Because just in case the grantor of the trust does not, or the grantor of the trust has probate assets in their name at the time of their death, you want everything to pass cohesively according to the terms of the trust, which is the real estate planning document in that case. And so you have this little pour-over will, it's usually very short, but it makes sure that any of those probate assets pour over to the trust and everything passes to the beneficiaries cohesively. The other big problem that dissuades a lot of people from using a revocable trust is that it needs to be funded during the lifetime of the grantor in order to be effective. And so that means that assets need to be moved from the grantor's name into the name of the trust. So if you've got real estate, that real estate needs to be deeded to the trust. If you've got a brokerage, you need to change the ownership to the trust or add the trust as a TOD. It can be a lot of homework for some people to take on, and a lot of clients aren't up to that challenge. I will say though that, the good thing about working with a financial advisor or an RIA such as Savant is that we can help you to move your assets into the trust and really make sure that the trust is an effective part of your plan. So the one other thing that I want to note is about taxes. Of course, because estate planning has a lot to do with death and taxes. During the grantor's lifetime, the revocable trust uses the grantor's social security number. So creating and funding that revocable trust has no impact on the grantor's income or estate taxes. At the grantor's death, an irrevocable administrative trust may be established that needs to file for an EIN with the IRS, which is an entity identification number. It's sort of like the trust social security number. And again, if spousal trusts or sub-trusts for descendants are created under that revocable trust, they'll also need a new EIN and they'll need to file their own tax returns. That sort of tax planning, though, happens whether you've got a will or a revocable trust. So whether you've got either one of these documents, will, revocable trust, it will name a lot of people in there. Generally with estate planning, you have to have, as Dom mentioned, a lot of trust in those people that you're picking. And generally, those people are called fiduciaries. So the primary person or people that you'll need to pick for your will is going to be an executor. An executor is a person or institution appointed by the testator to carry out the terms of the will. So the person who's going to be responsible for opening the estate and transferring assets from the testator's name to the final beneficiary who's named in the will. If you have minor children, the will may create a trust for their benefit, like I mentioned, or if you have an RLT, there will be a successor named, and they'll name that trustee who is the person that holds and administers property for the benefit of those beneficiaries. Same thing, if you've got a legal guardian or if you've got minor children, your will name a legal guardian who will be responsible for them until they turn of age and can handle their own affairs. In a revocable trust, like I said, that trust will name the successor trustee. They usually don't name a guardian. That's reserved for the will. They don't name a conservator. I would say a lot of times I would have clients that would, a lot of clients would struggle with naming these people. And so sometimes the initial trustee in a revocable trust would be the grantor. Then they would name their spouse. Then they would name their oldest child. Sometimes clients would want to name all of their children, usually in age order, so that none of the children felt unappreciated. That actually happened a lot. And the appointment of the executor or the successor trustee, that really helps with incapacity planning, that successor trustee especially, because you're going to have that person who's going to be able to step in and immediately access all of the assets that are in the revocable trust. So your family members, they're not going to have to go to court. They're not going to have to be appointed as a guardian or conservator, as Dom mentioned, because they're already going to have legal access to the assets and can make decisions on the grantor's behalf.
Alaina, this is great, good overview. And one thing that you said that I want to focus on is just who you name, right, in these positions that Alaina is outlining. is probably one of the biggest stumbling blocks for people that prevents them to actually executing and putting their plan into place. Because it is very difficult, right, to make decisions, especially if you have multiple children, right, or maybe you don't have children. But here's a practical tip that I wanted to share with everybody. I think it's all about progress, not perfection, because all of these documents that you put in place can be changed at any time, so long as you have capacity to change the documents, as Alaina said earlier. And keep in mind that the people that you name don't have to be subject matter experts when it comes to financial decisions and financial concepts, or even medical decisions, because those people that you name can get help from other professionals, right? Your financial advisor, your CPA, your attorney. They can be advised and then make decisions based on that input. So I think the best agents, executors, and trustees are going to be individuals that are not afraid to pick up the phone and call for help when they're unsure about something, and not be afraid to take action, right? Procrastination can be the enemy here, especially when you're dealing with settling someone's estate and paying their bill. So just a practical tip there if you're struggling thinking about whom to name. What do you think about that, Alaina?
100%. I mean, especially when I was in private practice, I saw people struggle with this all the time. And it's exactly as you said, they would put off signing their documents or doing their documents. And I will tell anyone, especially with minor children, that anything is going to be better than nothing, because the last thing that you want to have happen is to have a court decide who has guardianship over your children and then institute that conservatorship to manage their inheritance. That can be very stressful and a very expensive procedure for your family. So please, if you have minor children, please do at least some sort of basic will. And the other thing to remember too is that if you can't think of a person, or you don't have a natural choice, such as siblings, close friends, parents, anyone like that, there are also corporate fiduciaries who are available to act in these roles. Here at Savant, we have Savant Private Trust, which operates via National Trust Company, NATCO. And that really, that's allowed us as the financial managers to work hand in hand with our clients that have established these trusts for their family members. So it's hard. It's not always an easy decision, but anything is better than nothing. So with all of these people and all of these documents, how does property actually pass? And I have the most lawyer answer for that, which is it depends. So we talked about the difference between a will and a revocable trust. However, those documents only control a portion of assets. The will controls your probate assets, and the revocable trust controls assets that are transferred to it during the grantor's lifetime. Um, just there are so many other ways to transfer this property. For example, if you gift some of your property away during your lifetime, then it is not going to be controlled by your estate because you no longer have control over this asset. Crazy how that works. And so lifetime gifting can be a way to transfer assets. However, you do need to be conscious that if you're making large lifetime gifts, it can have an impact on your estate tax exemption amount, which is what controls how much your estate owes in estate taxes at your death. Generally, if you make any gifts over $18,000 a year to any one person, you should consult with your advisors, including your CPA, on how that impacts your estate tax exposure. And just one thing to note also, that $18,000 number is controlled by Congress and it's adjusted for inflation, so it may change every year. I was just reading somewhere it's estimated to go up to $19,000 next year because of inflation, so keep that in mind. But generally, if you gift over that amount, if you're single, or double that amount if you're married, you need to file a 709 gift tax return. And depending on what types of assets you're gifting, that can either be very easy or very complicated. So make sure you consult your advisors before doing any lifetime gifting. The other main way that assets pass at death is going to be via beneficiary designation. Many qualified accounts, including your 401ks and IRAs, those pass via beneficiary designation, where you've notified the custodians of those accounts that at your death, those accounts will pass automatically to that beneficiary. Anytime you're updating your estate plan, you need to make sure that you update those beneficiary designations accordingly so that they fit into the whole of your plan. They go hand in hand, so please don't forget. Same thing with property that's held jointly. Property that's held with joint tenants with rights of survivorship passes automatically to the surviving joint owner, whereas property that is held as tenants in common does not. Sometimes, if you're trying to avoid probate by having all assets pass via joint ownership, a tenancy in common can ruin that plan and cause your will to have to go through probate unexpectedly. So the last sort of beneficiary, the way to transfer assets is either a TOD or a POD. TOD stands for transfer on death and is usually added to brokerage accounts, whereas the POD, which stands for payable on death, is usually added to bank checking or savings accounts.
Alaina, if I could add, I think, from our perspective as financial advisors and estate planners, those misaligned beneficiary designations on 401ks and IRAs are just general, how do I pass this asset in coordination with my overall estate plan? That is like the biggest point of decision making, and we see the largest amount of gaps there. So I think it's really good to work with your team of financial advisors and attorneys for planning for the passage of those assets, because they are unique. And I love this chart, Alaina. Can you walk us through this?
Do you like this chart, Dom?
I'm a little biased.
Are you a little biased?
Yeah.
You have a reason to like it?
I really do. Go ahead.
So Dom made this chart. That's our little inside joke here. This is what Dom and I spend most of our days doing, is preparing charts just like this for our clients here at Savant so that they can physically see how their assets are going to pass, as opposed to having to read through 20 to 50 pages of wills and trusts. And, when you look at a chart like this, you see how many different pieces there are. You want to make sure that all of these pieces do align and coordinate for your estate plan. So now that, you're seeing this, you have your documents in place, what is next? What do you do next? Dom, can you give us some pointers?
Absolutely. Getting your document, making decisions, right? Designing your plan, and then actually implementing your plan are the first couple of steps. Then I think after you have a good foundation in place, it's really important to start thinking about getting organized, capturing important information that's going to be needed to administer your estate in the future, and then figuring out the right way and the timing of actually communicating your estate plan to your loved ones. And if you could, Alaina, actually skip forward to the other very colorful chart. I want to start there first on this section. Right here. Thank you very much. So, if you're listening and you're just sort of swimming, right, because this is a lot of information and just not sure how to get started, you're not alone. This stuff is not intuitive. Alaina and I are estate planners day in, day out, as a living and as professionals. And I think the one really important thing is really just to start thinking about that team that you're going to assemble to support yourself through all of this. Work with the financial advisors. You can understand the important income tax and estate tax concepts that Alaina was alluding to, right? And that financial advisor can help you with other financial planning needs, like retirement planning and education planning for children and grandchildren. But you're also going to want to work with a qualified estate planning attorney to put this together. so it works as intended. And the work doesn't stop after you sign your documents. As Alaina said earlier, to avoid probate on your assets, if you have a revocable living trust plan, for example, you actually have to fund that trust and change title of your financial accounts to the trust. So once you get your plan in place, go back, coordinate with your team of advisors and insurance professionals to make sure everything is properly aligned, right? Take another look at your beneficiary designations. Oftentimes, attorneys are providing some direction on how to align those, sometimes not. So there's a lot of potential stones to be left unturned. And having a good team of professionals can give you a little bit more confidence that you're not missing anything in this whole process. So if you could go back, Alaina, to the balancing act slide, please. So just tying this back to some of the overall goals of our presentation, right? It's really important, I think, when you're designing your plan, to make it efficient, right? You want to keep things low cost, minimize needless income and estate tax, preserve independence, meaning that your family can administer your plan, without court involvement, with a revocable living trust plan. And like Alaina said, start thinking about how you might want to protect assets for your loved ones, especially if you have young children or you're concerned about a possible divorce with one of your adult children, or concerned about some other creditor protection issue. I think the most important thing that rises to the surface in this list is really promoting and preserving family harmony. To me, at least, they're all important, but this one really stands out to me. So on the next slide, we have a couple of thoughts when it comes time to getting organized, because I think one of the things that can really cause ripples is when there's a lot of unknown, right, with what you owned. So Alaina, on the next slide, we have a nice graphic. And I mentioned earlier, we're going to provide a copy of this estate and trust administrator's guide, because your legal documents themselves don't necessarily capture important information like who to contact if something happens to you or your spouse, where are important documents located, right? Who is your team of professionals, right? Why did you name a certain executor or agent or trustee, right? Providing context behind the decisions, right? Because those legal documents just nominate the fiduciary and kind of lay out their roles, duties, powers, right? How you want your affairs to be handled, but it doesn't have the why, right? The rationale. And sometimes providing that rationale can go a long way into promoting, again, that family harmony, right? Ambiguity is the enemy, right? If you have multiple children, right, or other loved ones, right, you could encourage them to work together, even though you named one particular child, right? Not because you love that child more than the others, but just because, they lived closer to you, or, maybe they work in finance, or they're a nurse or a medical practitioner, right? So there's a lot of things you can do, beyond the actual legal documents to make your plan work better. And then just getting organized, right? Inventorying your assets, your estates, your estate assets, your liabilities, who you owe money to. It can go a long way when you pass away, because being an executor or trustee is a little bit of a thankless job. So one of the greatest gifts you can do is just creating a nice trail of breadcrumbs. So your executor, your trustee, your family, loved ones that are going to be stepping into this role aren't running blind, right? Trying to discover what you owned. It just removes a little bit of work from the process, so they can focus on grieving and supporting each other. So just a couple of thoughts there. And then,
Dom,
go ahead.
if someone fills this out,
Mm-hmm.
who should they give it to, or what should they do with it once they've compiled that information?
So it's a good question. I think you'd want multiple copies of it. You should keep a copy with your other important documents, like your actual legal estate planning documents, original life insurance policy, auto titles, that sort of thing, and like a fireproof safe at home is our suggestion. And you can even provide a copy of this to your financial advisor to keep it on file as well, to refer to. The next thing I was going to say is, do I communicate what my plan says? Do I share my documents with my family? I think it depends, as Alaina would say, right? Based on your comfortability, how old your intended agents are, how old your children are, right? Are they taking an active role in your life right now, assisting with finances, right? Or will they be in the future? I think at the very least, you should let your agents, your executors and trustees know that they've been nominated in the documents and where to find the documents, right? They're in the fireproof safe at home, or they're in the vault at the law office that created the documents. Here's my financial advisor's phone number. Here's my lawyer's phone number. If something happens to you, I think that's a great starting point. But when the timing is right, and again, usually it's when you get to an advanced age, you might want to sit down and have a family meeting, right? And really bring your children, or again, other loved ones, if you don't have children, into the fold so they can be educated in how all this is going to work, and be a little bit more prepared when the time comes. And it goes, again, it promotes that family harmony so everybody's on the same page. All right. And then Alaina, you mentioned probate. Can you just give us an overview of what that looks like?
Yeah, of course. So we've just got a few minutes left, and I want to make sure that we have some time to answer y'all's questions at the end. So I'm just going to give you a quick summary of the probate process. I can't go into a lot of detail because probate is very state specific and I don't want to get sued, but I can give you a 30,000-foot view. So generally what I've seen is if a will has to go through probate, what people expect, is what they've seen on TV. On TV, there's usually a gathering of the family. Everyone waits with bated breath to see what they're going to inherit. The executor is announced, not who the family expected, and it's all very dramatic. Usually the beginning of the probate process is really not that spectacular of an event. Whoever is nominated as the executor, they'll go through that state-specific process of filing the will with the court. Eventually, the court will give some sort of legal authorization that allows that executor to access the decedent's assets. They will pay any final bills. They will file any final tax returns, things like that. And then they will distribute the assets from that deceased person's estate to those final intended beneficiaries. Sometimes it'll be to a trust created under the will. Sometimes, if it's a pour over will, it will go to the trustee of that revocable living trust. Everything depends on what was written in the will. On the flip side of that, we've got the revocable trust, where you have a trustee instead of or in addition to that executor. However, the roles are very similar. There's just a lot less court involvement. And so the trustee is responsible for administering the trust assets, collecting the trust assets, any assets that were owed to the trust, anything that's coming from the probate estate, and then passing those assets on to the final beneficiaries. They will also be responsible for paying the tax returns if there's anything owed, there's not enough money in the probate estate, paying any final debts, things like that. The one difference, though, that we see between what the executor has to do and what the trustee has to do is the trust agreement while the grantor was alive, that was completely revocable by that grantor. Once the grantor passes away, that trust agreement becomes irrevocable. It's very hard to change at that point. I mentioned earlier that trust laws have become a little bit more lenient. And so there are some things that can be done, but generally the trust agreement is irrevocable by anyone. And then finally, everyone's favorite topic, which is taxes. Again, death and taxes. This is everyone's favorite webinar. Dom, can you give us a little bit of overview about estate taxes?
Absolutely. We saved the best for last, right?
The best.
Well, the reason we wanted to include these next couple of slides is because one of the main questions that we get is, hey, when I die, do my kids have to pay taxes on their inheritance? Right. And I think it's important to note that there's really two different types of taxes that can come into play. There's an estate tax, which is the tax on the transfer of your wealth And then there's income taxes, which are taxes that are paid on the generation of income from the assets themselves, right? Interest and dividends, capital gains, withdrawals from retirement plans, that sort of thing. And I think one of the big takeaways is from a federal estate tax standpoint, you can pass up to $13.61 million per individual in 2024 to anyone that you'd like without incurring any federal estate tax. So if you're a married couple, that's a tad over 27 million that you can pass federally estate tax free. And that's a very high historical number. You can see on screen, we have a bar chart just tracking the federal exemption going back to 2011. And I think an important note here is that you'll see in 2026, there's the federal estate tax exemption is set to be cut in half roughly, because the Tax Cuts and Jobs Act is going to expire. And we expect maybe a $7 to $7.5 million exemption. So if you're going to have an estate tax problem after sunset, or maybe you do now, it just means that there's some more planning to engage your attorney and financial advisor on to help minimize those estate tax exposures. Now, the next slide is just a reminder that the state that you live in might have an independent estate or inheritance tax that you'll have to plan for as well. And many times that state-based estate tax is less or a lower number than the federal threshold. And then on our final slide, just a couple of points tying this all together. After you pass away, one of the functions of your executor or your trustee is to file income tax and estate tax returns, depending on the situation. So the estate and trust income tax returns report income generated by your estate assets, your trust assets, right? Interest, dividends, capital gains. And then the estate tax return is filed based on the value of your estate, if you're subject to estate tax, or the surviving spouse wants to file for portability, which is another concept we can cover at a later webinar. And we've got a couple of minutes for questions, but before we get there, go ahead, Alaina, a couple important items.
Yeah, so while we won't have time to address everyone's questions live today, if you'd like to discuss your unique situation, please schedule a complimentary 15-minute call by clicking on the link in the chat to schedule a time that works for you, and someone will get back to you with an answer to that question. But we are going to address a few questions today that have been submitted throughout the presentation. I will, so you can see where we are.
Here's a good one, Alaina, that came through. What's the cost of setting up an estate plan? That's one that comes up quite often.
Yeah, for sure. So, I mentioned this earlier. There is a reason why not everyone does a revocable trust-based plan, right? Because those plans do tend to be a little bit more expensive than a will-based plan. When I was in private practice, I have seen everything from, LegalZoom costing $300 for a will-based plan to, clients with very high needs and very complicated plans requiring up to $30,000. But I would say for most people, you should expect to pay between $1,000 and $3,000 for good help from a local attorney. Don't quote me on that. Again, don't sue me. But, you want to work with someone who is going to be knowledgeable in this area, someone that can really help you with your own unique needs.
I agree 100%. Estate planning is very specialized, as you've seen, just all the content that we covered, and you want to work with somebody that generally specializes in it from a practice standpoint. I think we have time for one more question. And do I need a will if I have a trust? It comes up all the time. I'll answer this one, Alaina. And Alaina did speak to this earlier in the presentation. But wills are documents that dispose of your estate, but they're subject to probate, right? And they do allow you to name guardians for minor children. Trusts are legal instruments that also dispose of your estate, but they avoid probate. So I think the answer is you would actually benefit from having both. At a bare minimum, a will, because a will is the foundational document. But again, if you're looking to avoid probate, have additional ways to deal with incapacity, a revocable living trust is advisable as well. Speak with your attorney, get their opinion, of course. Thank you all for your attendance today. It's been really fun. We hope to see you next time.
Thank you.
Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.